Can police ask a person for their phone password after they invoked Miranda? Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing the Roadside Chat. This question comes from an officer, I think Pennsylvania, but it's not crystal clear. All right, so look, the officer says, I have a case where a juvenile invoked his right to remain silent after being advised of his rights. Fine. The officer then received consent from his mother to view his phone. And the officer also obtained a search warrant for the phone. So we have consent and a search warrant. Good to go. I mean, we can dive into whether or not the consent would have been valid. You know, the answer is probably, but it's not crystal clear sometimes. We need more facts. But really, the officer is asking this. Since the juvenile has invoked his right to silence, can I even ask him for the passcode? Or do I have to wait for a cooling off period? All right. So a couple of doctrines in play here before we can answer the question. When a person invokes their right to silence, they're off limits for any testimony, anything that's incriminating, for a significant period of time. The Supreme Court has used the phrase, you have to scrupulously honor their invocation. But they're not off limits forever, right? In one case, the Supreme Court found that 2 hours was sufficient. Other cases, the cops waited an overnight period, like a sleep cycle. But the point is, waiting a significant period of time. Then you can go back at that person. The next question is, okay, Anthony, do we even have to wait any time? Because is a passcode even testimonial? Does this fall under the Miranda prohibition, right? And the answer is yes. You know, giving the testimony basically are those things in your mind that you have to think about and those things that can incriminate you. Well, clearly you have to think about your passcode to a degree, and clearly giving up a passcode to a device where there's incriminating information on there can incriminate you. So you can't bypass Miranda on this. If the person has invoked, you have to comply with the rules to reinitiate. Here, I think if you had a sleep cycle, you're more than fine, maybe even less in certain circumstances, but you're going to want to articulate a significant break in the reapproach. Then you can reapproach after a significant period of time, wherever that is for you. Then you can reapproach them and say, hey, I like to, talk to you and so forth. Read a Miranda. If they give a waiver, then you're good to go. Just so you know, though, if the juvenile would have invoked his right to counsel, if he says, I want an attorney, then you're off limits for 14 days, right? And that is really one of the issues here with Miranda, because it can be very harsh. If you can reapproach him after you scrupulously honor, 2 hours in one case, but 14 days for an attorney. The Supreme Court said that in a case called Shatster, that was, enough time to allow that person to seek counsel, decide whether or not they're going to hire an attorney, and then you can go back at them. So the number is very, very arbitrary, but is the number that we have today. All right, there's your question. Hopefully, or there's your answer. Hopefully it helps. I would ask that you do something small for me. Like, subscribe, share with your friends. That just helps show, YouTube, hey, these types of videos are helpful to people like you. Until next time, my friends, stay safe.